In this module, I want to cover the topic of intergovernmental interactions. And specifically, what I want to focus on here are limits on state and local government power because the existence of a national government and of other states. To be more specific, what I want to cover is 4 topics. The first is, when are state and local laws preempted by federal law? The second is, when do state and local laws violate the Dormant Commerce Clause or the Privileged Immunities Clause of Article 4? Third, I want to talk about, are state and local taxes unconstitutional? And fourth and finally, I want to talk about, what are the requirements of full faith and credit when it comes to judgments from courts? Now, the topic for this module is titled Intergovernmental Interactions. Many of the things that relate to this topic, as pertain to the powers of the federal government, are covered in the module that I've done that discusses the powers of the federal government, the powers of the judicial, legislative, and executive branch. So in that module, in discussing those topics, I've discussed, for instance, the relationship of the federal courts and state governments with regard to sovereign immunity, or the requirement that federal courts abstain and not interfere with pending state court proceedings. I've talked about the scope of Congress's power in that module, including how Congress cannot commandeer the states and force states without laws or enact regulations. All of those are about intergovernmental interactions, but the focus in all of those is on what the federal government is doing. Here, what I want to focus on with regard to intergovernmental interactions are limits on what state and local governments can do. And as I said, I want to cover 3 topics with regard to this. Sub A, my first topic here with regard to intergovernmental actions, is preemption. Article 6 of the Constitution contains what is known as the Supremacy Clause. The Supremacy Clause says that the Constitution and laws and treaties of the United States made pursuant to it are the supreme law of the land. Well, what this means is, if there's a conflict between federal law on the one hand and state or local law on the other, the federal law wins out. The technical term is, the state or local law is deemed preempted. Preemption is one of the most important forms of intergovernmental interaction. It's very much based upon the supremacy of the Constitution and laws and treaties made pursuant to it over all other laws. Preemption can be found in any one of 3 separate ways. Point 1, express preemption. If a federal statute explicitly says that federal law is exclusive in a field, then state and local laws are deemed preempted. That's express preemption. The federal statute explicitly says that federal law is exclusive in a field, then state and local laws are preempted. That's express preemption. Any time that Congress has the authority to act, Congress in a statute can say that federal law is exclusive. Then state and local laws are preempted. As I said, that's express preemption. I'll give you an example. The Federal Meat Labeling Act says that only the United States Department of Agriculture may prescribe grades or labels for meat. Thus, states can have no beef over their inability to regulate meat labels because there is express preemption. Point 2 is implied preemption. Even if a federal statute is silent about preemption, implied preemption can be found in any one of 3 ways. Sub A, if federal law and state law are mutually exclusive, then the state law is deemed preempted. If federal law and state law are mutually exclusive, then the state law is deemed preempted. This is sometimes called conflicts preemption. If it's not possible to simultaneously comply with both federal law and state law, they're mutually exclusive, then the state law must give way. I'll give you an example from a Supreme Court case. A federal agency adopted a rule that said that all maple syrup bottles sold in the United States have to have labels stating their ingredients. The state of Wisconsin actually adopted a law saying no maple syrup bottles sold in that state could have a label stating their ingredients. Obviously, it would be impossible for somebody to simultaneously comply with the federal law required and the state law prohibited. They were mutually exclusive. They were in conflict with one another. Thus, the state law was deemed preempted. An important qualification here, though, and that is that states can set stricter environmental and safety standards than federal law, unless Congress clearly prohibits this. States can set stricter environmental and safety standards than federal law, unless Congress clearly prohibits this. So California can set stricter air quality standards than the Federal Clean Air Act. Texas can set stricter water quality standards than the Federal Water Pollution Control Act, unless Congress clearly prohibits this. It's not deemed a conflict with federal law for states to set stricter standards unless Congress has prohibited it. For this matter, states can provide more rights under their Constitution, under their laws, than the United States Constitution, unless, of course, there's an indication that there's preemption in that area. Sub B, if a state or local law impedes the achievement of a federal objective, the state or local law is deemed preempted. If the state or local law impedes the achievement of a federal objective, then the state or local law is deemed preempted. Sometimes this is called object preemption or objectives preemption. If Congress has a clear goal and the state or local law is interfering with achieving the goal, then the state or local law will be found preempted. Again, an example from a Supreme Court case. Florida adopted a law that said that anyone who files an unfair labor grievance with the National Labor Relations Board cannot collect unemployment benefits from the state of Florida. The Supreme Court said, when Congress created the National Labor Relations Board, it wanted to encourage people to file grievances with it. For Florida to punish those who filed grievances by denying them benefits, if the state impermissibly interfered with achieving the federal objective. The state law was thus deemed preempted. In sub C, if Congress evidences a clear intent to preempt state and local laws, then state and local laws are deemed preempted. If Congress evidences a clear intent to preempt state and local laws, then state and local laws are deemed preempted. This is sometimes called field preemption. If Congress has evidenced a clear desire that federal law wholly occupy a field, then state and local laws are deemed preempted. The most important example here is immigration law. The Supreme Court has said that Congress has evidenced a clear intent that federal immigration law wholly occupy the field. Thus, any attempt by state and local governments to regulate immigration will be deemed preempted. We saw this in 2012 when the Supreme Court in Arizona versus United States found key provisions of Arizona's restrictive immigration law, SB 1070, to be preempted by federal law. So even when the statute is silent about preemption, implied preemption we found in any one of those three ways. And finally, point 3 with regard to preemption is that states cannot tax or regulate federal government activity. States cannot tax or regulate federal government activity. Long ago, in McCulloch versus Maryland, the Supreme Court declared unconstitutional a state tax on the Bank of the United States. Chief Justice John Marshall quite famously uttered that the power to tax is the power to destroy. States, if they could tax the federal government, might tax it out of existence. This has led to a simple principle. It is unconstitutional to pay a state tax out of the federal treasury. States cannot tax the federal government or its operations. This isn't extended to say that states cannot regulate the federal government if they be placing a substantial burden on federal activity. States cannot regulate the federal government if they be placing a substantial burden on federal activity. These are the ways in which preemption can be found: express preemption, implied preemption, state taxation and regulation of federal government activity. If any of the ways that are discussed is present, then the state or local action is deemed preempted. Federal law wins out. My sub-B topic with regard to intergovernmental interactions is the Dormant Commerce Clause and the Privileges and Immunities Clause of Article 4. What I want to discuss here is when do state and local laws violate the Dormant Commerce Clause or the Privileges and Immunities Clause of Article 4. This is a particularly complicated area of constitutional law, so I want to break it down for you, and I want to give you an approach that you could use for any exam question, any case you deal with in practice concerning the Dormant Commerce Clause and the Privileges and Immunities Clause of Article 4. I want to begin in point 1 under B with definitions. There are 3 concepts that I want to define for you. A, the Dormant Commerce Clause. The Dormant Commerce Clause is the principle that state and local laws are unconstitutional if they place an undue burden on interstate commerce. The Dormant Commerce Clause is the principle that state and local laws are unconstitutional if they place an undue burden on interstate commerce. Notice there's no provision in the Constitution that says this. The Supreme Court has inferred it from the grant of power to Congress to regulate commerce among the states. But imagine that Congress has not acted. Its commerce power lies dormant. Nonetheless, a state or local law will be found unconstitutional if it's found to place an undue burden on interstate commerce. Notice then that there are 2 distinct meanings to the Commerce Clause. One is authority for Congress to act. I discussed that in the module concerning federal powers. The other is a limit on what state and local governments can do. That's the Dormant Commerce Clause. How do you know which to apply in a law school exam question? If you're in practice, how do you know which body of law to use? Always focus on who is the actor in the question. Is it Congress doing something? Then the question is, does it fit within the scope of Congress's power? Or is it a challenge to something that a state or local government has done? Then that's what I'm discussing here, the Dormant Commerce Clause. Sometimes this is referred to by justices, by professors, as the Negative Commerce Clause. Sometimes it's called the negative implications of the Commerce Clause. Whatever phrase you use, Dormant Commerce Clause, which is most commonly applied, Negative Commerce Clause, negative implications of the Commerce Clause, they mean exactly the same thing. It means that a state or local law that places an undue burden on interstate commerce is unconstitutional. Sub B, the second term I want to define, is the Privileges and Immunities Clause of Article 4. The Privileges and Immunities Clause of Article 4 says that no state may deprive citizens of other states of the privileges and immunities it accords its own citizens. No state may deprive citizens of other states of the privileges and immunities accorded to its own citizens. Notice from this phrasing that the Privileges and Immunities Clause of Article 4 is an anti-discrimination provision. It limits the ability of a state or local government to discriminate against out-of-staters with regard to what could be termed privileges and immunities. In a bit, I'll talk about what are privileges and immunities and what the clause applies to. What I want to highlight for you now is that the Privileges and Immunities Clause of Article 4 is an anti-discrimination provision. It limits the ability of a state or local government to discriminate against out-of-staters with regard to what are deemed privileges and immunities. In sub C, the third term I want to define for you is the Privileges or Immunities Clause of the 14th Amendment. Bottom line with regard to the Privileges or Immunities Clause of the 14th Amendment is to this point, it has been used only by the Supreme Court to protect the right to interstate travel. The Privileges and Immunities Clause has been used only to protect the right to interstate travel. Now let me explain. The Privileges or Immunities Clause of the 14th Amendment has majestic language. It says no state may deprive any citizen of the United States of the privileges or immunities of United States citizenship. I think this was meant to protect people from their own state governments, while the Privileges and Immunities Clause of Article 4 was meant to protect people from other state governments. But it didn't work out that way. In the first case to ever interpret the Privileges or Immunities Clause of the 14th Amendment, the Slaughterhouse cases in 1873, the court gave this clause an incredibly narrow construction. The Supreme Court's interpretation was so limiting as to effectively read it out of the Constitution. The court said that federal courts could not use the Privilege or Immunities Clause to strike down state or local laws. Isn't it amazing? 5 years after the 14th Amendment was adopted, the Supreme Court interprets the Privilege and Immunities Clause and says it can't be used to strike down state or local government actions. So from 1873 until 1999, only once did the Supreme Court find a state law to violate the Privilege and Immunities Clause. And that 1935 decision was overruled 5 years later. But in 1999, the court rediscovered the Privilege and Immunities Clause. The case was Sines versus Roe. It involved a California law that said if a person moved into California from another state, welfare benefits of the first year of residency to the level of the state the person moved from. The case involved a woman who moved from Mississippi to California. So under the law, for her first year in California, welfare benefits would be at the Mississippi level. The Supreme Court declared this unconstitutional. The Privileges and Immunities Clause of Article 4 wouldn't apply here because the state wasn't discriminating against out-of-staters. It was conceded that the woman had moved permanently to California. She was a permanent resident of California. California was just discriminating between its longer-term residents and its new residents. But the court nonetheless declared the California law unconstitutional. The Supreme Court said that the right to interstate travel is protected as a fundamental right under the Privileges and Immunities Clause of the 14th Amendment. The court said that the effect of the California law would be to chill interstate travel and migration. It was found to be unconstitutional. This is the only Supreme Court case that has not been overruled, striking down a law based on the Privileges and Immunities Clause. The only time that it's been used, as I said, is to protect the right to travel. Well, it's with these three definitions in mind that I now want to go to point 2 under subunit B, and that's the key question. Does the state or local law discriminate against out-of-staters? Whenever you're dealing with an issue under the Dormant Commerce Clause or under the Privileges and Immunities Clause of Article 4, always start by asking, does the state or local law discriminate against out-of-staters, or does it treat in-staters and out-of-staters alike. Usually, state and local laws do not discriminate. You might remember from law school the many cases that involved state laws regulating truck length and truck width. Those laws were not discriminating. They applied to all trucks operating in the state, whether owned by in-staters or out-of-staters. Sometimes, though, state and local governments try to help their own residents and their own citizens at the expense of out-of-staters. They thus adopt laws that discriminate against out-of-staters. You might remember the famous case Philadelphia versus New Jersey. New Jersey adopted a law that said that no out-of-state garbage could be buried in New Jersey landfills. The law was blatantly discriminatory against out-of-staters. The Supreme Court found that it violated the Dormant Commerce Clause. Or another more recent case was Granholm versus Held. Michigan had a law that said that in-state wineries could ship wine directly to consumers through the mail, but out-of-state wineries could not ship wine directly to consumers through the mail. I confess that until I read this case, I didn't even know there were wineries in the state of Michigan. But the Michigan law was clearly discriminatory. It was about giving a benefit to the in-state businesses that it was denying to the out-of-state businesses. It was on that basis that the Supreme Court declared the law unconstitutional as violating the Dormant Commerce Clause. Whenever you see a question about the Dormant Commerce Clause or the Privileged Immunities Clause, whenever you see a case about it, always focus on the question, does the state or local law discriminate against out-of-staters? Point 3 is the analysis if the state or local law does not discriminate against out-of-staters. Sub A, the Privileged Immunities Clause of Article 4 does not apply. The Privileged Immunities Clause of Article 4 does not apply if the state or local law is not discriminatory against out-of-staters. Remember what I said in the definition just a few minutes ago. The Privileges and Immunities Clause of Article 4 is an anti-discrimination provision. It limits the ability of a state or local government to discriminate against out-of-staters. If there's no discrimination, it doesn't apply. Sub B, if the law puts a burden on interstate commerce, it violates the Dormant Commerce Clause if the burdens on interstate commerce outweigh the benefits from the law. If the state or local law puts a burden on interstate commerce, it violates the Dormant Commerce Clause if the burdens on interstate commerce outweigh the benefits from the law. Even if a state or local law is not discriminatory against out-of-staters, if it's a burden on interstate commerce, it can be challenged as violating the Dormant Commerce Clause. If the law is not discriminatory, a simple balancing test is used. The court weighs the burdens on interstate commerce against the benefits from the law. If the burdens outweigh the benefits, the state or local law is unconstitutional. I'll give you an example of a case you might read in law school. Illinois adopted a law that required that all trucks operating in the state have curved mud flaps. Almost every other state allowed straight mud flaps. The Illinois law did not discriminate against out-of-staters. It applied to all trucks operating in the state, whether owned by in-staters or out-of-staters. Nonetheless, the Supreme Court declared the Illinois law unconstitutional. The court said the Illinois law put a substantial burden on interstate commerce. Either trucks would have to avoid Illinois or stop at the border and change their mudguards. The court said it could identify no benefit from the Illinois law. There was no evidence that curved mudguards are safer than straight mudguards, because the burdens on interstate commerce outweighed the benefits from the law was found to violate the Dormant Commerce Clause. Point 4, under major subpoint B, is the analysis if the state or local law discriminates against out-of-staters. In point 4, I want to have the analysis you use if the state or local law does discriminate against out-of-staters. Sub A, if the law puts a burden on interstate commerce, it violates the Dormant Commerce Clause unless it's necessary to achieve a very important government purpose. If the law puts a burden on interstate commerce, it violates the Dormant Commerce Clause unless it's necessary to achieve a very important government purpose. The Supreme Court has said that there's a strong presumption against state and local laws that discriminate against out-of-staters and put a burden on interstate commerce. Such laws will be upheld only if the state or local government meets a heavy burden. The state or local government is going to have to show there's a very important interest served. Now, to be clear here, the Supreme Court has never expressly articulated whether it has to be compelling or very important or important, but the court has said it's like strict scrutiny, though they haven't used the word compelling. The court has made clear what I've described this as. It has to be something very important to justify discrimination. Additionally, the state or local government is going to have to show that its law is necessary to achieve that objective. This requires the state or local government show that no less discriminatory alternative can achieve its goal. The state or local government is going to have to show that no less discriminatory alternative can achieve its objective. In fact, there is only one Supreme Court case where it has upheld a law that discriminates against out-of-staters and puts a burden on interstate commerce. The case is Maine versus Taylor, and it's a good illustration of the test that I've just described. Maine adopted a law that prohibited importing into the state out-of-state bait fish. The state was concerned that the out-of-state fish might carry parasites that would endanger species indigenous to Maine. And so the Supreme Court said that the Maine law, while it was discriminatory, was still constitutional. The court said Maine had a compelling interest in protecting its natural resources, and the court said that there was no less restrictive alternative, so the law was necessary to achieve the goal. There are, however, a couple of exceptions. These are situations where a law that would otherwise violate the Dormant Commerce Clause will be upheld. One exception with regard to the Dormant Commerce Clause here is congressional approval. Congressional approval. If Congress has approved the state or local law, it's then permissible, even if otherwise it would violate the Dormant Commerce Clause. If Congress has approved the state or local law, it's then permissible, even if otherwise it would violate the Dormant Commerce Clause. If you think about it, once Congress has acted, its commerce power is no longer dormant. Once Congress has acted, the matter is outside the realm of the Dormant Commerce Clause. So, if Congress has approved the state or local action, it is then permissible under the Dormant Commerce Clause, even if otherwise it would violate the Dormant Commerce Clause. The other exception here is called the market participant exception. The market participant exception says that a state or local government may favor its own citizens in receiving benefits from government programs or in dealing with government-owned businesses. A state or local government may favor its own citizens in receiving benefits from government programs or in dealing with government-owned businesses. I'm going to give you two illustrations. If you remember my examples, you'll always know the market participant exception. First example, the University of California can charge less in tuition to in-state residents and more in tuition to out-of-state residents. Why doesn't that violate the Dormant Commerce Clause? After all, the state or local law is discriminating against out-of-staters. It's putting a burden on interstate commerce from discouraging people from coming to school in the state. The reason this is allowed is the market participant exception. The University of California is regarded as a government benefit program. The state can prefer its own citizens who have long been paying taxes to support the program over out-of-staters who have not. Now, by contrast, if California had a law saying private colleges and universities charge less to in-staters and more to out-of-staters, that would violate the Dormant Commerce Clause. It's just that the government program itself can favor in-staters over out-of-staters. My other example here comes from a Supreme Court case you might remember. The state of South Dakota owned and operated a cement factory. The state-owned cement factory charged less to in-state purchase cement and more to out-of-state purchase cement. Though it was a hard case, one you can't take for granted, the Supreme Court upheld the South Dakota law. The court explained that this was a government-owned and operated business, that the government here was literally the market participant. And the court said that that justifies the exception under the Dormant Commerce Clause. The state's allowed to do so. Now, if South Dakota had a law saying private cement companies should charge less to in-staters and more to out-of-staters, that would violate the Dormant Commerce Clause. The market participant exception just says that a state or local government may benefit its own citizens in receiving benefits from government programs or in dealing with government-owned businesses. Sub B under point 4 concerns the Privileges and Immunities Clause. Specifically, if a state or local government discriminates against out-of-staters with regard to the ability to earn a living, it violates the Privileges and Immunities Clause of Article 4 unless it's necessary to achieve a substantial government interest. If a state or local government discriminates against out-of-staters with regard to the ability to earn a living, it violates the Privileges and Immunities Clause of Article 4 unless it's necessary to achieve a substantial government interest. I want to break this down for you step by step in terms of what you need to know about the Privileges and Immunities Clause. Little one, there must be discrimination against out-of-staters. There must be discrimination against out-of-staters. I said this a couple of times. I repeat it because the single most important thing you need to know about the Privileges and Immunities Clause of Article 4, it applies only when there's discrimination against out-of-staters. Little 2, the discrimination must be with regard to fundamental rights or the ability to earn one's livelihood. The discrimination must be with regard to fundamental rights or the ability to earn one's livelihood. Now, fundamental rights are rarely litigated under the Privileges and Immunities Clause, though they could be. Imagine if California adopted a law saying no out-of-staters can criticize the governor of California. That would clearly violate the Privileges and Immunities Clause, but in reality, that would just be challenged and struck down for infringing the First Amendment. If the government is keeping out-of-staters from exercising a fundamental right, you don't need the Privileges and Immunities Clause. Just strike down the action for infringing the fundamental right. And the court has said this is limited to those rights that are deemed fundamental. Just a couple of years ago, there was a case in the Supreme Court involving a Virginia law. It said that only citizens of Virginia could receive records from the state under its Public Records Act. Out-of-staters who wanted records in the Public Records Act couldn't get them. A challenge was brought. The Supreme Court upheld the Virginia law. The court said the Privileges and Immunities Clause doesn't apply because there's no fundamental right under the Constitution of access to government records. The other place where this applies, and where it's really used, is when a state or local government is discriminating against out-of-staters with regard to the ability to earn a living. Think of the leading Supreme Court cases here. An earlier case was Toomer versus Witzel. South Carolina adopted a law that said if a person wanted a commercial shrimp fishing license, and the person was an in-stater, a $25 fee, but if a person wanted a commercial shrimp fishing license, and the person was an out-of-stater, a $2,500 fee. The court said this discriminates against out-of-staters and their ability to earn a livelihood through commercial shrimp fishing, the law was found to violate the Privilege of Immunities Clause. Well, you might remember a later case, Piper versus New Hampshire. New Hampshire had a law that said, in order to be admitted bar in New Hampshire, one had to be a resident of New Hampshire. A woman who lived across the border in Vermont brought a challenge to this. She won. The Supreme Court saying that in order to be licensed to practice law in New Hampshire, to be a resident of New Hampshire, discriminated against out-of-staters in terms of their ability to earn a livelihood and thus violated the Privilege of Immunities Clause. Compare these examples to another case you might remember. Montana had a law that said if a person wanted an elk hunting license and the person was an in-stater, a small fee, but if the person was an out-of-stater and wanted an elk hunting license, a much larger fee. A challenge was brought under the Privilege of Immunities Clause. The court rejected the challenge and upheld the Montana law. The court explained that elk hunting is a hobby. It has nothing to do with earning one's livelihood, so the Privilege of Immunities Clause of Article 4 did not apply. Little 3, under sub B about the Privilege of Immunities Clause, corporations and aliens cannot invoke this provision. The third thing about the Privilege of Immunities Clause, corporations and aliens, non-United States citizens, cannot invoke this provision. Long ago in the 19th century, the Supreme Court said that the word citizen in the Privilege of Immunities Clause refers to those who are United States citizens. Thus, corporations and non-citizens cannot take advantage of this provision. I have an important, though I hope obvious, tip for you for common law exam questions. If the plaintiff in the question is a corporation challenging a state or local law that discriminates against out-of-staters, use only the Dormant Commerce Clause in your analysis. But if the plaintiff is an individual citizen who's challenging a state or local law that's discriminatory, then you're going to need to consider both the Dormant Commerce Clause and the Privilege of Immunities Clause in your analysis. And little 4, the discrimination will be allowed only if it's necessary to achieve a substantial government interest. That's the phrasing from the Supreme Court. The government's going to have a substantial interest. I think that means the same thing as a very important interest. And the means are going to have to be necessary. As I said once more, necessary here is that the government will have to show that no less restrictive alternative can achieve its objective. So if you pull together what I've said about the Dormant Commerce Clause and the Privilege of Immunities Clause of Article 4, you have an approach you can use for any question or any case you see. You always start by asking, does the state or local law discriminate against out-of-staters? If the answer to that is no, then the Privilege of Immunities Clause is inapplicable, and the law violates the Dormant Commerce Clause if it's a burden on interstate commerce and the burdens outweigh the benefits. But if the law is discriminatory, then with regard to the Dormant Commerce Clause, if it puts a burden on interstate commerce, it violates the Dormant Commerce Clause unless it's necessary to achieve a very important government purpose. Keep in mind, though, the two exceptions, congressional approval and the market participant exception. And if the state or local law is discriminating against out-of-staters with regard to the ability to earn a living, then it violates the Dormant Commerce Clause unless it's necessary to achieve substantial government interest. That then completes sub B on the Dormant Commerce Clause and the Privilege and Immunities Clause of Article 4. Sub C is state and local taxation of interstate commerce. When are state and local taxes with regard to interstate commerce unconstitutional? Now, the reality is you could analyze this under the Dormant Commerce Clause and come to the same result, because the state and local taxes are being challenged because of their burdens on interstate commerce. But I could also articulate for you a few other rules to apply, specifically when it's a challenge to a state or local tax on interstate commerce. Most important, point 1, states may not use their tax systems to help in-state businesses at the expense of out-of-state businesses. States may not use their tax system to help in-state businesses at the expense of out-of-state businesses. You might remember the leading cases here. Ohio had a law that said if a person purchased ethanol produced in-state, the person would get a tax credit. But if the person purchased ethanol produced out-of-state, no tax credit. The law was obviously trying to help in-state producers at the expense of out-of-state producers, and that's why it was declared unconstitutional. Well, you might remember the many state laws that said if a person purchased dairy products produced in-state, a small tax. If a person purchased dairy products produced out-of-state, much larger tax. The states were obviously trying to milk as much business as possible for in-state dairies, and so those laws were declared unconstitutional. Point 2, under subpoint C. A state only may tax activities that have a substantial connection to that state. A state only may tax activities that have a substantial connection to that state. Imagine a business that wholly operates in New York with little or no connection to Texas. Texas cannot tax that business. Texas can only tax that which has a substantial nexus, a substantial connection to the state. And finally, point 3, state taxation of interstate companies must be fairly apportioned. State taxation of interstate companies must be fairly apportioned. This is really a corollary of point 2. Imagine an interstate trucking company that operates in all 50 states. California could calculate the percentage of miles traveled in California compared to the rest of the country and tax that percentage of revenue. Or California could calculate the percentage of revenue earned in California compared to the rest of the country and tax that percentage of revenue. So long as the tax is fairly apportioned, so long as the state only is taxing that which is connected to it, the tax will be allowed. Those are the basic principles about state taxation of interstate commerce. Finally, major subpoint D with regard to intergovernmental actions is full faith and credit. A court in one state must enforce a judgment from a court in another state so long as all of the following requirements are met. A court that's in one state must enforce the judgment from a court in another state so long as all of the following requirements are met. 1, the court that issued the judgment must have had both personal jurisdiction and subject matter jurisdiction. The court that issued the judgment must have had both personal jurisdiction and subject matter jurisdiction. Point 2, the judgment must be on the merits. Point 3, the judgment must be final. Here's an illustration. Imagine the students in my class file a lawsuit against me for intentional infliction of emotional distress. They sue me for my dumb jokes. They sue me because class begins at 8:15 in the morning this semester on Mondays, Tuesdays, and Thursdays. It would be truly a class action suit against me. And imagine that they get a judgment against me in California Superior Court. They can go to any other state. They can go to state court, they can go to federal court, and ask those courts to enforce the judgment against me. Imagine that I own property in other states. They can go to those states and ask the courts in those states to enforce the judgment against that property. In other words, the courts in these other states must give full faith and credit to the California court's judgment so long as all the requirements are met. First, the court that issued the judgment against me had to have personal jurisdiction over me and properly subject matter jurisdiction over the controversy. Second, its judgment must be on the merits of the dispute. And third, its judgment must be final. If all of these requirements are met, then a court must give full faith and credit, must enforce the judgments from the courts in another state. That then finishes this module, which is focused on intergovernmental immunities, looking at preemption, the Dormant Commerce Clause and the Privileged Immunities Clause of Article 4, state taxation of interstate commerce, and full faith and credit.